And now we're joined by Pete Holmes, who's running for re-election as city attorney. So go ahead with a 2-minute introduction.
Thank you very much, and thank all of you for your service. This takes a lot of time on a beautiful evening when you could be outside. You know, I ran for city attorney 8 years ago for the first time, and I came for this office not to hold elected office just for the sake of holding elected office, not just to go through a campaign, not just to have authority or something, but because I have specific things I wanted to do in this office. I had served, if you recall, as chair for, gosh, about 5 or 6 years of the city's very first civilian oversight board for the police department, the OPA review board. And in that capacity had really gotten a pretty close up look at not only the Seattle Police Department, but the way city council and the mayor's office interact and function with each other. And in particular, the city attorney's office. And it came to me after a number of years that one of the obstacles was an office that was not committed to police reform or transparency, and consequently I felt that I could do a much better job, especially after about 25 years at that point in private practice as a civil litigator, learning how to be a trial lawyer, learning how to practice this craft. Now, 8 years later, I'm asking voters for a third term, and I have just the same amount of fire in my belly. There is so much, not just to rest on laurels. And we can talk about the amazing things we've been able to accomplish in office. When we think about the fact that we're well into a federally monitored consent decree, and the police department is really making progress. We've got a long way to go, however, a long way to go. We have really, I think, turned the world over on its axis a few degrees at least when you consider 502. And I put my office on the line. I can tell you that when I came back from the first announcement where we were kicking off 502, and my chief of staff said, "I hope you enjoyed being a one-term city attorney." I said, "It's okay, we're doing the right thing."
Great. So now we have our 4 prepared questions. Feel free to turn over the sheet of paper in front of you to read along as we read them aloud. These are 2-minute answers. And Nicole, will you do number 1?
Sure. What should the city attorney do to complete the Department of Justice reforms affecting our police department?
Part of this is a little bit under a bit of a restriction because of things that are happening. You know, this city has secret bargaining with its unions, which is the law of the city, and it is the law that I insist that we follow. But it's probably fairly widely known that while we've been 5 years under a consent decree and made a lot of progress and have assessments from the federally appointed monitor that the city is making definitive, measurable progress, we still lack contracts with our 2 main unions. We're 4 years out with SPOG and 6 years out with the SPMA, the Seattle Police Management Association, which is the union for captains and lieutenants. And while I am normally a glass half full guy, some days I feel like it's a glass half empty, because I not only help advise on the negotiations that are nearing what's called an impasse, and I can't say any more than that, but I also have to be, I'm the city's chief legal officer in the litigation that's going forward. On Monday, we will argue in the 9th Circuit the Mahoney case, where about 100 police officers, it's down to 92 at this point, have sued to overturn all of the reforms that we've created over the last 5 years. So that's about 10% of the force that's actually in court suing to overturn that. When Chief O'Toole tries to make discipline decisions, they do not stick because of contract rights and other problems with the collision of state law and federal constitutional law. So a city attorney is one that's needed that knows all the terms of the consent decree and is willing to risk being a target of union ire, police union ire, let's make a distinction here, and willing to stay the course.
Jason, number 2.
Do you support the city's current policy on homelessness encampment suites? If so, why? If not, what would you do differently?
The policy, first off, stated most simply, is and should be that we extend appropriate services to anyone that is unsheltered and we do it on a case-by-case basis with individualized caseworker approach. If we do that and provide appropriate services, and that's the $64,000 question, or 64 million, then we also need to be prepared to move forward and say that for public safety, for instance, we cannot have encampments under interstate highways, for instance. We have to be willing to say, we are offering you these alternatives. We have done our best, and we believe we're meeting our obligations to treat you in a humane way, to be what you might call a compassionate disruptor. And we do have to say, though, that the option of staying here is not an option. It's no longer an option. Provided we've provided the realistic, humane alternatives, we have to be prepared to follow through. That's why I've had to, on the one hand, draw the line of when, for instance, I will allow criminal charges to be filed for trespass or obstruction or things like that. I've made it very clear that we won't file charges unless you show me that individualized outreach. At the same time, I've had to defend the ACLU lawsuit, which, while raising valid concerns, is also not being fully practical and recognizing that the city has to run. We have to be able to move the city forward. And that means being able to take compassionate but disciplined measures and holding the course, being steadfast in that. You will be second guessed. That's the nature of elected office, and you have to be willing to endure that and move forward.
Great. Ben, number 3.
Should the city change its approach to prosecuting misdemeanor offenses? And if not, why? If so, how?
Yes, and we are changing our approaches. The one thing is the mantra in our office is that misdemeanors matter. And it's not just that I like alliteration, but it's actually there. And when you think about it, my office receives about 14,000 arrest reports for misdemeanors in the city of Seattle annually. And we have about 24 prosecutors to handle that, so do the math. What we are, though, trying to get away from is a much more assembly line factory approach that typifies most misdemeanor municipal practices across the country, where you might have 6 different prosecutors touch a case over a period of time where they have been set and reset for hearings. Instead, I want to have what's called vertical integration. We already do that with our DV cases, where it's so critical that you know not only the offender but the victim, and you become the liaison with the witnesses, i.e. the law enforcement officers, and you're with that case from filing to disposition. And while we're doing it for DV, we're trying to do it for all other cases. Now, the biggest component of that, when you have those resources, you can identify those cases where, I'm sure you're all familiar with what's called the sequential intercept model, where a lot of the problems that we have in densely urban areas are with between opioid addiction, homelessness, mental illness, all of these social and medical public health problems that we have. When you intercept them earlier on the circle, before it becomes criminal, and before it's gotten into felony land, for instance, going past the misdemeanor, the earlier you can intercept and intervene and really get at the underlying causes rather than the behaviors that result from them, then you get better results. And so we're trying to do that now even before we file charges. Can't do when arrest has been made, but we get the case and now we get to decide, are we going to file charges? It's called pre-filing diversion. We're working on it now.
Item number 4.
So how would you respond in the event of a federal crackdown on marijuana?
Well, I first off take heart that Governor Inslee and Attorney General Ferguson have been very clear that they are going to defend what our voters put into place in the 502 system. Incidentally, because neither one of them supported 502 when it was on the ballot. I would just point that out, which really speaks well for them. I mean, actually, it makes them in some ways, when you've got this crazy Trump administration, they can say, we too were skeptical. We too had concerns. We were concerned about the law enforcement side, but so were we. And I think what I tell when I'm speaking to industry groups and the like is that as much as I fear the kind of irrational Twitter feeds that we get from time to time, or in the case of Attorney General Sessions, we're getting these suggestions they want to roll back and go to the old, the choice that, whether it's marijuana or police enforcement, that you can either be safe and be tough on the law, or you can be, suffer the consequences. It's a false choice. You can either be safe and submit to a heavy-handed criminal approach, or you can, just make your choice. We've shown that that's a false choice, and I think that the state of Washington in particular should be really proud, and I tell investors this as well. I said that, compared to Colorado, we really are showing the better path. In Seattle, we had 130 to 150 unregulated medical dispensaries with lots of 911 calls and other complaints associated with them, some doing really good medical work. But after legalization, we now have about 42 fully regulated, licensed stores in their place, and every single one of those unlicensed dispensaries are gone. They folded without an arrest, without a shot fired, because we substituted regulation for prohibition. And I think we can just make the case that it's the better choice.
Great, so now we'll open up to follow-up questions. These are 1-minute answers. Ben, Bevan, and John.
So right now, to prosecute a police officer who's killed someone, state law requires the prosecutor prove malice and bad faith. Would you be an advocate for reform of this law, and what would that reform look like?
Yes. I have already signed the last year's initiative 871. I endorse that. Moreover, my criminal chief, Kelly Harris, participated in the state's task force, the legislative task force that attempted unsuccessfully to come up with better language. We have to remove the good faith and malice requirements and substitute it for objective, reasonable standard. It's really that simple. The state is the hardest in the entire country to prosecute. And I've been on the record in my very first year in office after the shooting of John T. Williams, when their attorneys, the estate's attorneys, asked both Satterberg and me to prosecute. I think Dan correctly stated the law, and I went a step further and said, and we need to change it. That was back in 2010, and we even offered the amendment, the language, take out the malice standard. Just objective reasonableness is all that you need.
Bevan, and then John.
What will the city attorney's office do to make sure that refugees and immigrants are protected under the umbrella of our sanctuary city?
We are a sanctuary city. It's been wonderful that one of the first things I did was to file suit against President Trump. That could have been fun. How did he sign the executive order? He signed the complaint the same way. That's part of it. I mean,
Did you hold it up for the camera?
I couldn't handle it that much, but I take it a little more seriously, I think, than he does. The other thing, ever since that election, I always show this, it's getting really boring. I carry this around, and I'm grateful. I have to thank him for the opportunity to study the Constitution more than I have since the first year of law school. But, we have to do things, it's across the board. For instance, when I was in office, the first 6 months, one of the low-hanging fruit that we had, in some ways, Washington is a sanctuary state, I like to say, because if you recall, under our dysfunctional federal immigration law, if a non-citizen is convicted of a minor crime, gets 365 days deportable because it's a felony under federal law. We took 1 day off, and then the next year, the state took 1 day off every misdemeanor sentence statewide so that we wouldn't deport unwittingly.
Great, John.
Sorry.
And then I have one. Go ahead, John.
Devin stole my question, but I have a related one. Do you have any other ways that you think you can fight back against this administration from the city level? What's the role of your office in the city in fighting back, not just on this issue, but on other issues?
Well, I think that we're pushing on. There's more to be done, for instance, under drug policy. Here's a perfect example. Trying to roll back the misguided approach that you're going to criminalize everything that's causing discomfort in a densely populated urban area is our default setting, right? Everything it looks like a nail goes, all we use is a hammer, as the old saying. And so I think, for instance, in the case of safe injection sites, there's a classic example that I'm excited about because I am not qualified to tell you how you should run them, where they should be, or anything like that. But I am the lawyer that can help disengage from the criminal justice system, hand the responsibility to the appropriate medical experts, and then make sure that zoning and licensing and other things like that are done. That's what the lawyer should be doing to extricate us from, we've been putting the lines of business in the wrong professions, right? And so that's where the lawyer, using the law to make things better, that's our role.
Okay, so I have one. So you were one of the few candidates to qualify under the Democracy Vouchers program. I think may have been the first one to qualify. I'm just wondering, what has that experience been like? A lot of us supported the idea before it was implemented, so what are your thoughts?
It's been actually really fun. I gotta say, I told Dave Croman and a couple of other journalists that have been following it, because it is an experiment, right? And I'm always excited about trying new things. Don't be afraid to try it, and then if you have to change course, do it. But in this case, it was amazing to me, first off, that, I mean, everyone in this room knows what democracy vouchers are, and I promise you, the next 10 people you talk to outside say that not in the 36 will not know what the hell you're talking about.
Right.
And so, I start to explain, for instance, go and get me those signatures first. That's what I had to do, $10 and a signature to qualify to get these. And they go, what? And a couple of people would say, I'll sign it, give you $10 if you just stop talking about it. And I said, that's fine, I'll take it. It's gonna hurt my feelings, but so I just think it's a great experiment, and I'm really dedicated to seeing if it really works. I'm really hoping that my opponent is not going to use democracy vouchers, has no restrictions. I'm going to still try to stay with the cap.
Great. We have time for another question or two. Clayton, and then Jason.
To return to John T. Williams, I can't stop and one reason is I can't stop wondering whether or not malice and intent can be measured by the clock. If a man is shot 4 seconds after a policeman gets out of a car, it implies that that policeman knew he was going to shoot him before he got out of the car, took one step, and blew him away. And the fact that this argument has not been voiced in court implies that the legal system is implicit in that kind of malice. And I just like your comment on this perspective.
I think about it a lot too, and in that case, there was a strong argument, and it wouldn't be fair to talk, to share the conversations that I had with Dan Satterberg. I like Dan. We have agreed on many things, like, for instance, human trafficking and going after the demand side. We're in lockstep on that, and that's been really gratifying. There was a strong argument. Why not just put it to the jury? Yes, it's a tough standard. Why not go ahead and do your best case, tell them the law, and then see what happens? I told, when we prosecuted the drone case, my prosecutors were really, if you remember that case on the Pride Parade, that was exactly the same thing. My prosecutors were convinced we weren't going to be able to get a conviction under simple reckless endangerment, because we needed some specific prohibition on flying drones, unmanned aircraft over, and there is no regulation of it. And I said, we're going to do it because we'll do one of two things. If you do a really good job and win, okay, you've gotten the message out. And if you lose, then you and I are going to go down to Olympia and say what new law we need.
Jason, final question.
Yes, I'm going through the expungement process in Alabama, and I'm on the 4th expungement in process 3.
I was going to ask where you're from.
Right. Sound different. So in the state of Washington, correct me if I'm wrong, I think we can vacate one. How can we improve that system where an individual like me who probably had an incident dismissed, satisfy restitution, etc., so on, clean that record up and move forward?
Well, I think we're making progress. Let's face it, we have, Olympia is kind of a microcosm of what goes on in DC, right? We have the red rural areas that have a different view on these things, a much more law and order approach. 502, we've offered 4 years in a row, for instance, making it easier to vacate what is no longer a crime, simple possession case. How stupid is that? It's not a crime anymore, and yet people are still carrying that weight around just simply because they were caught with a joint a year or two before it became illegal. We're doing that with prostitution, making it easier for women particularly who want to get out of the life and want to be free of that, of those past convictions. So we're doing it piecemeal, is the best thing I can say. And I always believe you go for what you can get. And that's the same approach to your earlier question about Trump and all that. We keep trying to improve.
Thank you.
So we are out of time. If you want to take 30 seconds for a closing statement.
Sure. Again, I want to thank you guys. This is really so needed. It's really pleasing for me. My wife will tell you, we both went to law school together. My long-suffering wife of 35 years, we got married before law school. And she'll tell you, I'm the only guy that she knows that can get excited talking about the absolute priority rule. How do you calculate present value? Because I'm a multi-lawyer and I get genuinely excited about it. I'm just as excited about this job today as I was 8 years ago. And I have a lot more things to do. I'm grateful that I've got a challenger now because, I'm kind of using some muscles I haven't used in 8 years. I'm grateful that you guys care enough about it to hear the wonky lawyer tell the story.
Great. Thank you very much.